Hi, it's Anne-Marie from Charmed Life Therapy. Back with another little update. Again, it's been a few days where I've kept going to make a video and then thought, oh, it's just changing on a dime, is this? On a whim. It's like you'd no sooner have the video made than it was already kind of out of date, really. And then there's been one or two interesting little bits and pieces, I guess. In the meantime, I caught a little bit of Ryan Reynolds on Jimmy Kimmel last night, and it's really conflicting for me because, as I've told many of you before, I'm supposed to be doing A Course in Miracles, which I am doing. But A Course in Miracles is all about not judging people. It's about forgiving people. It's about we're all one. So it's like to cast aspersions on Blake and Ryan. You're affecting yourself, which is all true. But it's very difficult, isn't it, when you come up against narcissists in the world? It's like, well, where does narcissist? I'll have to do some deeper research into how A Course in Miracles works when you're dealing with narcissists, because it's very, very difficult, isn't it? But I was watching Ryan on Jimmy Kimmel, and I just look at him, and I think I just see now that it's just a very hurt little boy, really. He brought up this idea again of being a people pleaser. It's like he's decided that he's a people pleaser. It's like either a therapist has given him that, or he's come up with it himself in his own research. So he believes he's a people pleaser. So it's almost like it gives him permission to come down like a ton of bricks on people, maybe, because it's like, I'm not going to be a people pleaser anymore. Being a people pleaser got me nowhere in the past. But I don't get the sense, like from the bits that we've learned about his childhood, that he really was a people pleaser. I think he was probably knocked back a lot by his father and things like that. And the bits that I've seen of his mother, I don't find her all that appealing. I do believe he's probably had quite a difficult childhood, maybe, from what little I know. But I just find him overwhelmingly exhausting at this point when you see him on anything. It's like, just be a real person, isn't it? He has to go on about Hugh Jackman and spout nonsense about Hugh Jackman and him having a slot machine addiction and just going on and on and on and going on about eating his children's candy and the candy being like ayahuasca. It's like it's like this is what makes me think little boy. It's like he's never grown up. It's like, oh, I'm going to talk about drugs and it's going to be so salacious. Aren't I risky talking about drugs, talking about perineums, talking about body parts? I'm really going to push the envelope. It's like, to me, it's like little boy pushing the boundaries all the time. That's the sense that I get. I feel like I'm like really ghostly little. I don't usually make videos at night. I've got the scary light going on behind me, and I'm not a professional studio. But yeah, I just found it really difficult to watch last night because I think you see him deteriorating before our eyes, Ryan Reynolds. And I don't necessarily say that to enforce you to go into sympathy mode, but I do think he's looks like somebody who's gone through the ringer at this point. He's like folding in on himself. It's like he's becoming a crone in front of our eyes, I think, in some ways. And it's like it's so strange to witness because it's all about him. There's very little mentioned about Colin Hanks, who's the director of this John Candy thing. It's like everything he talks about is as if he single-handedly did it all. And again, he was reiterating the Bill Murray story and how he stayed at Dan Aykroyd's. And it always has to have some kind of weirdness or some weird element to it, or they have to have been weird and he has to have been the one coping with all the weirdness and freaking out or whatever it is. And it's just like, just be normal, isn't it? It's like, just answer a straight question. And it's like the interviewers are just so frustrating because it's like, pin him down to something. you know, Kimmel could have said, "Oh, I'm aware your wife's having a really hard time right now. How are you all managing to cope with that?" There might have been an interesting question to ask. How are you managing to cope with, um, going around the country on this tour while your wife's dealing with this massive legal case? But of course, all of that will have been decided beforehand that he's not going to talk about that. He's going to turn up and spout nonsense about ayahuasca and his children's Halloween candy. But what was interesting was everybody went straight to the comments when the first thing out of Jimmy Kimmel's mouth was that he was adored everywhere, that Ryan Reynolds was adored everywhere he goes. And it's like, I don't think Kimmel's keeping up with the news. He must have been too concerned with his own business lately. But yeah, I increasingly find Ryan very, very hard to watch, and it's just like your shtick is going to get you nowhere at this point, mate, because we're not buying it. You can keep saying all the nonsense you like, but it's not really working anymore, is it? And then we've got then we've got Nicole Kidman and Keith Urban splitting up. And it's a funny one, is this? Because I know a load of people are going to say, I told you so. But I remember years ago when they were still dating, and I saw a picture of them out on the street somewhere. And that was before I'd done any training in counselling. But I've always been really intuitive, and I'm very good at spotting what's wrong in things, which is very hard for me to live with, but very good in a professional sense. But I saw that this picture of them on the street while they were not long together, and he was linking her arm, so his arm was through hers, and I just thought, nah, because straight away you could see she was in power, and it's like people are intimating now. She looked motherly then. It was like a mother with a boy, especially it doesn't help that she's taller than him, clearly, and she's more imposing, isn't it? And I think that's the problem. She's clearly a strong woman, and I don't think he's a strong man. So I think there was always going to come a time when you couldn't look past that imbalance. And especially like when he had his troubles early doors, didn't he? And I think he's had at least one spell since or something. So I don't think it's that surprising now, as she's like a mature woman, and I don't know. I've never really seen it. I've never found them appealing as a couple. I've never completely bought it. I mean, I'm sure in the beginning it was passionate and the rest of it, but I just think they were really mismatched. I just didn't see it. You can't mother somebody forever. And I think the fact that you're it's allegedly, possibly, that he's moved on with somebody, that watching Popcorn Planet just a little while ago, and it was saying that he sung a song that he wrote for Nicole on stage, and he swapped out the baby, which was in reference to Nicole, and swapped it with the name of the guitarist that was on stage with him, this 25-year-old Maggie. And I just thought, oh, it's so tedious, isn't it? It's so predictable. If that is true, it's like, well, he's never grown up, has he really? And that's the problem. So now, is he going to go off and date a 25-year-old girl? And I think she was like, oh, did he just do that on social media? And she'd clipped the video, hadn't she, to her own feed or whatever. And it's like, lady, you should absolutely just run. Because you don't want to mother this man either. Don't be thinking, wow, isn't that awesome? She's clearly not thinking he wrote that song for his wife and now he's directing it at me. Is that something that I want? It's like, no, girl, get out while you can. Done. And it's like he's ditched his entire band or something, isn't it? It's like midlife crisis alert. Is he still trying to be young and relevant? You know, Nicole's clearly still powerful, still capable, still pushing the envelope in her own work, isn't she? And maybe been spending too much time away and the rest of it. But yeah, I've just never really bought the relationship, I don't think. Because she is strong. She was married to Tom Cruise for 10 years. she's learnt a great deal about being strong if she wasn't strong before, and I suspect she was pretty strong before, you know what I mean? Um, no, I've never really seen it. I think it would have been a relationship where she was always in charge, always in the power mode, and eventually the guy gets tired of that, doesn't he? Because although he needs it, certain men that are like that have weaknesses or whatever, they start to resent the powerful woman at some point or other. That's just kind of what happens, really. And what's the best way to defeat a powerful woman who's like in her mid to late 50s? It's like, go get somebody younger, isn't it? And it's a bit tiresome. It's a bit tiresome. It's as tiresome as the Ryan Reynolds appearances on TV. But yeah, I thought I better show up and do a little bit on documents just to keep up with things. So obviously we've had Blake's side's objection to this motion to dismiss on the pleadings, basically. And as far as I know, at this point in time, I haven't been able to read it because it's not there on Court Listener, but I think Wayfarer have till tomorrow at tea time, 5 o'clock, New York time, I guess, to respond to their extension to Blake's request for an extension of what, a month to deal with this if necessary. I think that's where we're at. Let me just bring up some docs and then we'll see where we are. Which one is it? It is this one. Right, so hopefully you can see this. Let's have a look. So is that highlighted a lot? Oh, which one is it? So that is 8:34. That's 8:35. So we'll buzz through this one quite quickly because I'm sure you will have seen some of it elsewhere or got the bones of it. But they're clearly very, very cross at the Blake side. They've not seen this coming. I think they were certainly would have been expecting a motion for summary judgment after all the depositions were complete, but I don't think they've been expecting this motion for a judgment on the pleadings. So let's just kind of whiz through most of the highlighted bits. So they're clearly quite angry. So to be clear, Ms. Lively is prepared to respond to each of the Wayfarer defendants' arguments at the appropriate time, whether that be at the summary judgment stage or at trial. And this is interesting, really, because she keeps hovering over this idea of being at trial. The other day, she was very, very worried, wasn't she, about Josh Greenstein and being able to depose him first because she would get to question him first at trial. And if she didn't get him to question him first at the deposition, that might taint the jury and all of this. She vacillates between trying not to sound like she's really worried about a jury and a trial, and then she moves into, oh, I'm not bothered about being at trial. I'm so confident in my case. She kind of goes between one or the other, depending what's going on. But the Wayfarer's defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that briefing and adjudicating them now would only lead to doubling up on everything, basically, and wasting judicial resources. She's always, for somebody that puts so much on the docket, she's always telling the court how she worries about wasting judicial resources. When it comes to Wayfarer being able to respond to something or put into something into motion for themselves. So she believes that would force her and the court to bear the burden of the Wayfarer defendants' delay. Tellingly, although each of the Wayfarer defendants' arguments has been available to them since the outset of the case, and although their counsel alluded to the possibility of a motion for judgment on the pleadings on the record at the conference held on July 30th, the Wayfarer defendants waited to file their motion until the response deadline would fall on the last day for depositions in this case, knowing full well that because of their own discovery deficiencies, Ms. Lively's counsel would be preparing for and taking the depositions of 4 of the defendants during that period. But it's like, she's made this kind of argument before about them dropping, like when she accused them of, there was 80,000 pages or whatever, and she accused them of dropping that strategically. But she fails to, she always never mentions what she does that is exactly the same thing, like when she dropped her second amended complaint the night before she was due to be deposed, you know. It's like it's like it's like it's almost staggering how she just completely whitewashes herself. So what's in this little footnote? So this motion asserts that Ms. Lively has failed to exhaust her administrative remedies against It Ends With Us movie, but the burden of pleading and proving the Title VII exhaustion lies with defendants and operates as an affirmative defence. So she's saying it's their fault, really, that it's their position. They're the one that has to exhaust things, not her. She doesn't have to try that hard. She doesn't have to prove anything. Malice doesn't have to be proved. She doesn't have to prove that she was suing the right people. Now that's Wayfarer's problem. It was part of it should have been part of their defence strategy. So not only does that render this argument inappropriate for resolution on the defendant's Rule 12 motion, It Ends With Us movie did not even raise this affirmative defence in its answer. In other words, not only did It Ends With Us movie move the judgment on the pleadings based on an affirmative defence it had not pleaded, but because of that failure, Ms. Lively would be entitled to judgment on this particular defence, not the CRD complaint, and received right to sue letters. Oh no, sorry, I've missed a line there, haven't I? So would be entitled to judgment on this particular defence, not It Ends With Us movie. So she's almost trying to say that they should have been working for her almost in effect if they were trying to plead that argument. In any event, and further demonstrating the wastefulness of the Wayfarer defendant's motion, Ms. Lively amended her CRD complaint and received right to sue letters with respect to It Ends With Us movie. During the pendency of this action, as is well established in this district, that is sufficient. So this is interesting, isn't it? Because people that, I mean, I can't remember it ever having been amended or it being acknowledged as having been amended or brought to the fore. And so far, everybody that I've seen as in terms of content creators hasn't heard of this. That she corrected the CRD and refiled it to include It Ends With Us movie. I don't know of that. And it's like, if she did Wayfarer know about it? Because surely if they knew about it, they wouldn't have phrased that as part of the argument. I don't know. So, so meanwhile, by the time the Wayfarer defendant's motion is fully briefed, the deadline for summary judgment motions will be only days away. So I think that's her saying basically by the time they've had chance to fully answer everything in that's in Wayfarer's request to have judgments on the pleadings just as they stand, by the time Lively's side have had time to fully answer all of that, she's saying the deadline for summary judgment motions will be only days away, meaning that each of the fact-bound challenges to the pleadings raised in the motion will be overtaken by the record evidence at the summary judgment stage. The question at this stage of the case is not what the pleadings allege, but what the evidence shows. She seems to be well, according to this document, she seems to think that she's pulled evidence that is going to be very, very helpful to her case through the discovery process. But if it's along the lines of what we've already seen, is it just further delusion? Because so far, everything that she sees as a smoking gun, we've all kind of looked at, and including all of those out there that are lawyers, like Omar and Not Actually Golden and Little Girl Attorney and all of the rest of them are saying, how does she think this is pro her? You know, so it's like, it's very hard, is this case. It really tests my spirituality, this case. My daily efforts to be a good person and not be judgmental. Meanwhile, to the extent the motion raises purely legal issues that would not be affected by the summary judgment evidence, the Wayfarer defendants will suffer no prejudice from the few weeks additional delay in briefing those issues. I mean, you can guarantee I think that if the judge gives Lively a month to answer this, you will be looking eventually at the trial date will be pushed back. That'd be the next step of it. Because although we're in October and what is it, March, it's supposed to go into trial, it's no time at all in legal terms, is it? That it seems like a few months or what is it, 5 months? It's nothing in legal terms, I don't think. So blah blah blah. It's all of that. So fact discovery is scheduled to conclude on September the 30th. So thank God. That was yesterday, with a few exceptions, including a handful of fact depositions to be completed by October 10th, and the production of additional documents withheld on privilege grounds. So that's still slightly up in the air, isn't it? That Wayfarer have to produce another privilege log, I believe, and then there's still to be a decision on what is and isn't privileged. Since they dragged Jed back into it by pointing out that he was represented by Lina Friedman. So some of these things that Blake had won on, actually, no, you can't have it because Jed is represented by Lina Friedman. So that's still all going on. There's still to be a bit of a judgment there. But that was slightly more favourable to Wayfarer's side of things, from what I understand. So expert discovery is scheduled to conclude on November 14th. So that will include whatever expert is going to determine for Blake what her expenses is, what she's suffered through, what the value of that is in terms of her businesses, I guess, and her earnings and all the rest of it, and what's projected. But part of her expert discovery will be to do with that. Meanwhile, the current deadline for summary judgment motions is November 5th. The trial remains scheduled to begin on March the 9th. So there it's getting into the specifics of when a party may move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. So generally, a Rule 12C motion is considered timely if it is made early enough not to delay trial or cause prejudice to the non-movement. Whether a Rule 12C motion is timely is within the sound discretion of the judge. She's always like Gollum in terms of, it's like, my precious, isn't it? The judge is Blake Lively's precious. That's how things are phrased towards him. It's like, this is your area of expertise, Judge. We don't necessarily need a jury unless there comes a time where I have to argue that I don't mind being in front of a jury. Meanwhile, anything that can be done by you should really be done by you, Judge. And it just is like Gollum. If a party engages in excessive delay before moving under Rule 12C, the district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. And like, I think some of the argument here is Baldoni's side have kind of waited till like they needed specific expiry dates, didn't they, for parts of their argument to come into play. They needed that time span. If they had done it earlier, she could have moved to change a thing or two, couldn't she? But I mean, that all's fair in love and war, isn't it? She certainly would have done the same thing. So consideration of the motion may still be appropriate if, unlike here, it seems clear that the motion may effectively dispose of the case on the pleadings, but if the pleadings do not resolve all of the factual issues in the case, proceeding with discovery and potentially a trial on the merits would be more appropriate than an attempt at resolution of the case on the Rule 12C motion. Courts are unwilling to grant a judgment under Rule 12C unless it is clear that the merits of the controversy can be fairly and fully decided in this summary manner. The Wayfarer defendant's motion is untimely, although all of the arguments raised have been available to the Wayfarer defendant since the initial complaint was filed. They did not raise them until September 26th. Measured against this court's stated goal of managing this case to a March 9th trial date, that delay was excessive under Rule 12C. It's funny, isn't it? She's always telling them how they may litigate their own case. It's like she doesn't just want to run her own case. She feels it's her place to run their case too. So Ms. Lively has uncovered voluminous evidence relevant to all of her claims. So rather than merely defend the sufficiency of the allegations to respond adequately to the motion, it's interesting, isn't it? She completely bypasses. She says, it doesn't matter about the law. I believe I have enough evidence. And like I say, from if it's like what we've seen already, we beg to differ, don't we? But she just wants to completely bypass the idea that she's mistrying it in the first place. And so if you're mistrying it, it doesn't matter what evidence you've got anyway. So Miss Lively would also need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint, should any of the Wayfair defendants' arguments prove successful as to any of the second amended complaints claims. The court would then need to evaluate that evidence under Rule 15's futility standard. So she says, even if you give them this, I'm still going to argue, isn't it? I'm still going to fight. It's like, it's just like more. It's just like more of this. You cannot tell me what I can do, basically, isn't it? It's really hard. So, Miss, so the court would then need to evaluate that evidence under Rule 15's futility standard, i.e. under Rule 12b6's plausibility standard, construing that evidence in Ms. Lively's favour along with the benefit of reasonable inferences therefrom. But crucially, that would be the same analysis as at the summary judgment stage. So she doesn't want to, they really haven't seen this one coming, have they? They really did think they were safe until summary judgment stage. And that's probably been part of Wayfair's ploy to keep quiet and not mention it. So when if the Wayfair defendants chose to move against any of Ms. Lively's claims or defences, she would then need to point to record evidence that, construed in her favour and drawing reasonable inferences therefrom, would support a reasonable jury's finding in her favour. So she's stating very clearly there that she believes that this factual evidence, there is no question whatsoever in her mind that a reasonable jury would find in her favour. Not really sure how Blake Lively is going to find a reasonable jury at this stage, because she seems to find every human being that is on a lower power level than her. She finds those people inferior. So I believe Blake Lively is going to have a very hard job finding a jury that she considers suitable. Can you imagine when it comes to like the jury pool and that voir dire, I can never say it, voir dire that they do when they're selecting the jury. Can you imagine if she is sat there with her attorneys while they're jury picking? Can you imagine how that will go? Do you seriously think she's going to find anybody, unless they're wearing I Heart Blake Lively t-shirts, acceptable? So anyway, I'm not going to blag through all of this because most of it's a lot of stuff that I probably don't understand anyway. So she basically she's presenting arguments that are going to say it supports conducting that exercise only once. She's saying if they fail here, I'm only going to have to do it again because they'll try summary judgment or whatever then. So the Wayfair defendant's motion thus seeks a duplicative exercise that can only have the effect of causing delay. It's always telling the judge how bad these people are and how they cause such a problem. Meanwhile, it's like it really is just like you're just not allowed to have a defense against me. You're just basically just supposed to sit there and take it, as we've said before. Blake's whole problem was she just thought he'd have to just sit there and take it and pay her whatever money or whatever, or just lose his livelihood and the rest of it. And he was just supposed to not say or do a thing about it ever, 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 ever. Meanwhile, the Wayfair defendants will suffer no prejudice from having their present motion evaluated on the basis of the summary judgment evidence rather than the SAC's allegations. So again, it's her saying, no, I think you should litigate it like this. That will be perfectly acceptable to you. Who is she to determine that they will suffer no prejudice, that it won't harm their case by doing things her way? So, by contrast, Miss Lively will suffer significant prejudice from having to file what is effectively in opposition to summary judgment while discovery is still ongoing. So, she's completely, this is allowed. What Wayfarer have done, they are allowed to do in law. She just, so her objection is that she will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline. So she believes her case is going to get stronger and stronger with more and more evidence against him with every day that passes between now and the response deadline. She's so convinced that her case gets stronger every day. It's interesting, isn't it? She seems to think that when she gets these depositions of Baldoni, Heath and Wayfair and Sarowitz and Nathan and Wallace, not to mention the expert discovery process, that everything's just going to fall into place for her. So the court should deny the motion. In the alternative, Ms. Lively respectfully requests that her deadline to respond to the motion be extended to and including October 27th, 2025, 3 days after the deadline to exchange expert rebuttal reports. Unless extended, the current response deadline is October 10th. This is Ms. Lively's first request for an extension of this deadline. Well, yeah, because it's only just been filed. Oh dear. So what's the other one? Oh, let's go and have a quick look. Luckily, it's quite short. So this is about clarification. So let's have a look. Let's see if I can make sense of it. So in accordance with sections 1C, 1D and 3A of Your Honour's individual practice in law, I've commented over it so I can't see what it is. In civil cases, Plaintiff Blake Lively respectfully moves for clarification that the deadline for requests to admit is October 10th, 2025. So I had to go and look at what request to admit is. So this is when a party is asked to admit or deny specific facts that come up in discovery. So it might be to clarify something that's been said or prove the authenticity of a document. So it's supposed to make litigation easier. It's supposed to clarify things, I guess, ahead of time. So it's something that's considered a tool of discovery, if you like. So she's clarifying this deadline because obviously all of the depositions have shifted into this first part of October, haven't they? Or in the alternative, to modify the court's case management plan and scheduling orders to extend the current deadline to pose requests to admit from September 30th to October 15th. To the extent the court provides any clarification or relief as to the request to admit, the Jones parties also request that is equally apply in Jones versus Abel. Oh, it's amazing how those two can get on when it suits them, isn't it? Pursuant to the court's initial case management plan, the deadline for the parties to submit requests to admit was August 14th, which was the same as the last day for depositions and the last day for fact discovery. While the court extended the fact discovery calendar to September 30th and subsequently extended the deadline for depositions to October 10th, the parties failed to expressly confirm with the court that the extension to the deposition calendar to October 10th likewise extended the deadline for the request to admit to the last day of deposition. So Ms. Lively seeks confirmation that the deadline for requests to admit is October 10th, 2025. Now, whether that has any bearing on all the other stuff, I don't know. So blah, blah, blah. So she respectfully moves this court for an extension until October 15th for these requests to admit, if necessary, to permit the parties to incorporate deposition testimony into the request to admit. Good cause exists for Ms. Lively's request for an extension of the current deadline to serve request to admit. Furry Puppet Studio Inc. versus Fallout Boy. I'm so sick of seeing that. It was amusing the first time it popped up, and it's one of Judge Lyman's. But it's where she gets the excuse to say, good cause is likely to be found when the moving party has been generally diligent. The need for more time was neither foreseeable nor its fault, and refusing to grant the continuance would create a substantial risk of unfairness to that party. So it's the one that she bandies out whenever she says, I'm a really good girl and I'm doing everything the right way and I should get what I want. That's she brings Fairy Puppet Studio back into it. So the parties have taken 12 depositions between Friday and today, and 4 more party depositions across 7 days of testimony are scheduled to take place between now and October 10th. None of this testimony could reasonably be incorporated in requests to admit were the deadline September 30th. Additionally, Ms. Lively continues to receive party productions as recently as last night, as well as anticipates third-party productions into next week as ordered by the court earlier today. But so that she got some of what she wanted, didn't she? But it's still connected to this new privilege log and stuff. Some of it is still to be decided on, I think. So further, aligning the deadline for requests to admit with the last day of deposition testimony is both what this court initially ordered and what is warranted to permit the parties to seek admissions across all parties on an efficient and complete basis as fact discovery draws to a close. So the additional time will contribute to the just, speedy and inexpensive determination of the matter. Inexpensive by narrowing disputed issues for trial, including those issues that await deposition testimony that has yet to be provided. Blah, blah, more Fairy Puppet. Ms. Lively, of course, will suffer prejudice in being unable to obtain admissions from the defendants across a variety of issues that await party testimony. She's always suffering prejudice and retaliation, isn't she? This is the second extension that has been sought on the deadline for requests to admit. While Ms. Lively intended to file a stipulation regarding the October 15th deadline earlier in the day on September 30th and received consent from the Jones parties, she waited over 14 hours. I'm sure she patiently, personally waited 14 hours. I'm sure she was sat there waiting for the Wayfarer defendants to respond by email that they do not consent to the October 15th deadline without providing a reason, despite repeated attempts to secure their position during breaks of a party deposition. All right, so they were busy holding a deposition. The Jones parties consent to this extension. The Wallace defendants take no position. As far as I know, Wayfarer very rarely asks for more time, do they? And when Wayfarer does, everybody has already agreed to it, from what I can remember off the top of my head. So basically, that's where we are, really. We're waiting to see if Judge Lyman, I don't think he's going to grant her a month's extension. I would be incredibly surprised if he grants her a month's extension to deal with this. But will he give her 2 weeks where he might have only given somebody else 5 days or 7 days? That is a possibility, I think. Yeah, we will just have to see. But yeah, I didn't want to make a video the last couple of days because, especially over the other day when those emails were coming through, God, I can't even think what it were about now. It was Ellen's emails when she was backwards and forwards with Blake's attorneys. And I could just hear, and of course she got knocked on the head again, didn't she, Ellen? And it's like, I could just feel the narcissism coming through the emails. And, at one point during those emails, Ellen gave them a little bit of grace, the lawyers, because she said, I realise that your client is kind of unreasonable in all of this, that you're like literally just feeding what your client's immovability. And it's like, I could literally feel it seeping into my skin. And when I feel that happening, I know I need to step away because I know I don't want it in my psyche. And that's why continuing to do these videos is a decision for me because it goes against the nature of the way I'm trying to live my life. It's an interesting conflict to have because when I started these videos, this was not what it was about at all. It was just let's kind of analyze the emotions. But as time has gone on, I believe all of us that are invested in these things are by extension dealing with a form of narcissistic abuse. Each and every one of us, I am absolutely assuring you of this. If you are following this case, you have now been a victim of narcissistic abuse in a form. You literally have, because you will have had days where this was driving you absolutely nuts and you knew you couldn't do anything about it, and you knew no matter what you said or what you felt about it, it wasn't going to change the situation. And that is narcissistic abuse of a second-hand nature, if you like. And yeah, I don't really, in my bones, want to be talking bad about Blake and Ryan, even as bad as they are, and how much I resent what they're doing. Um, and every time I have to bring it back to the fact of this would not be happening if we weren't supposed to be learning something from it. And it's kind of incredible, isn't it, really, that I think it really highlights things when you realise that Blake Lively, in using 47.1 and all of that, she does not care. She's not even thinking about what if this wrecks 47.1? What if this is the downfall of 47.1? What if and whatever decision comes out of this that I have asked for actually leads to that piece of legislation crumbling so that other people can't use it? Because basically she's asking for all these special, it's like all of the law that she's trying to use has to be tailored to her specifically. She wants new versions of it all to cover her. And the more and more she bandies on and tries to use 47.1, the more 47.1 starts to look a bit unrealistic and unsafe and counter to the Constitution and all of the rest of it, because all of the focus is going to actually, when you pick it apart, this looks really shady. And she won't care one bit if 47.1 falls apart as long as she gets her own way. So that's the frustration, isn't it? Oh, and I'm tied into it now. I have to keep talking. No, I don't. I don't have to keep talking about it. I am choosing to keep talking about it and torturing myself with it. And God, I really do truly hope for my own sanity that the judge knocks a load of this case out, just on this pleadings. But it'll be interesting to see. I think, like most people, my feeling is denied in part, approved in part. I think that's where I'll head with it, as I'm sure you probably feel as well. We're used to that pattern of behaviour. Anyway, hope that was a little bit interesting. And please do hit that like and subscribe and share if you can. And I will see you again soon. See you later.